when you are paying for DSTV subscription, you are only paying to use those copyrighted works for private use. But once you allow other people to watch DSTV in your public place of businesses, in your bars, in your lounges, in your restaurants, at shows, you are using it for public and commercial use. Hello guys, today my name is Jeanette Odunye. I'm an entertainment lawyer and music publisher based in Lagos State, Nigeria. You're welcome back to my mini educational series where I talk about everything entertainment law, music publishing, and the music business in general. So today I'm going to be talking about this judgment that was just released concerning that surrounds copyright protection, rights of an author to the protection of his works. And this judgment is between Musical Copyright Society of Nigeria, which is a PRO in the Nigerian territory, and Broadcast Music Incorporation, which is BMI based in the US, versus Pyramid Regal Services Limited, which is an hotel. So basically, the decision was based on whether an hotel which uses a DSTV platform to disseminate information and entertain its guests or its clients in their business place, whether they need to get a license and pay a fee. So basically, the judgment centers around whether public places like restaurants, like bars, like hotels are expected to pay a fee to performing rights organizations for the use of DSTV content or for the performance of DSTV content in their public place of businesses. So basically, just made me remember when I used to work in my former place of business. It's a law firm, and so like they had a client, Audiovisual Rights Society of Nigeria, which is in charge of which is a rights organization for audiovisual works like films, movie series, and everything. So that was where I actually learned that normally when a public place of business uses any song, like maybe they play broadcasted content from AIT, from NTA, from Silverbird, or from DSTV channels, they are meant to pay a license fee to performing rights organizations or any kind of collective society for the use. So basically, in this judgment, the court is saying that as long as the hotel services has paid a subscription fee to DSTV, they don't need to pay another license fee to performing rights organization, because that would amount to double compensation. So I'm just making this video to give my thoughts on the judgment and how it can have an implication on the rights owners, the rights ownership, and the rights holders, and whatever copyright protection of music creatives and even movie creatives in Nigeria. So basically, you need to understand that when a piece of work has been created and it satisfies the copyright protection requirements, so the author itself has certain rights that are entrenched in those copyrighted works. There are about 9 to 10 to I think 11 economic rights that a author of a copyrighted work that satisfies the copyright protection requirements enjoys when he creates his work. So today I'm just be focusing on the right to public performance and the right to broadcast, which is the center of attraction, or which is the contention exactly in this case. Basically, what is the right to public performance? The right to public performance is the right to perform a piece of copyrighted work to certain individuals outside your close friends, family, associates, etc. So maybe for example, now you have a cinema in your house and you invite your friends, your family, your colleagues, your co-workers, your Gs to the cinema to watch a movie, to watch latest released movies and everything. That will not amount to public performance because it was only performed to a close circle of friends, family, and associates. So you don't need to pay a license fee. But the moment you take like maybe a projector and you put it in your place of business where it's accessible to anybody, close friends or associates or not, where it's accessible to the members of public, or maybe you put it on your street and let everybody watch it whether for free or not. That amounts to public performance, because you are performing that song, you are performing that movie, you are performing that copyrighted work to people outside your close families and friends, and that is beyond private use. So when it is a private use, there is also like public performance, but the moment it's beyond private use, then there is a public performance, and you as the user of the copyrighted work is expected to pay a license fee to performing rights organization. That's all about the right to public performance. Now I'm going to explain right to broadcast. Right to broadcast is the right to transmit sounds and images using wireless methods via non-interactive platforms. Non-interactive platforms are platforms you can watch you can use other copyrighted works, but you cannot choose when, where, how you want to use copyrighted work. For example, multi-choice as DSTV, they own DSTV booking and everything. You see DSTV, you cannot choose when you want to watch a show, you cannot choose how, you can record, you can download, but you cannot choose the exact time you want to watch a movie. Unlike Netflix as an interactive platform, you can always choose when you want to watch a movie, or you want to do this or that. So that's the difference between a non-interactive platform and an interactive platform. Netflix, Amazon Prime, Apple TV, they are all interactive platform because you can choose when and where you want to watch whatever show you want to watch. But DSTV, you don't have the liberty to choose. So when DSTV disseminates those kind of copyrighted work, that is broadcast, which is different from public performance, if you can understand. So they are transmitting this sound, these images, this copyrighted work using wireless method on their non-interactive platform. So you need to understand that when you are paying for DSTV subscription, you are only paying to use those copyrighted works for private use. But once you allow other people to watch DSTV in your public place of businesses, in your bars, in your lounges, in your restaurants, at shows, you are using it for public and commercial use. So when you're using it for private use, you cannot be called upon to pay a license fee for the use of that work. But the moment you use it for public use, is not much a private use, so you're expected to get a license. There are other economic authorship rights, like right to reproduction, right to publication, right to distribution, right to public display. There are so much more and everything. And we need to understand that these rights work independently. So now let me cite an example. So remember then, if you're a millennial, you remember then when we used to buy CDs to listen to music, or we used to rent movies from movie houses and all that. So you know that some of these movie producers and music producers, marketers, promoters, they go to Alaba International Market. If you are based in Lagos State, Nigeria, you go to Alaba International Market. They sell these markets as to make CDs available to everybody. So I know that time they didn't used to sign agreement, they just do word of mouth. But if it was in this present time when everybody is bent on agreements and all, so maybe for example a movie producer or a music producer goes to Alaba International Market and approaches the marketer that, oh, I want you to distribute this song or this movie for me, and let's distribute it for me. So basically the marketer is supposed to get the original CD of the music or the movie. It's supposed to reproduce different copies of it and distribute. So if I am to draft an agreement between that marketer and the movie or music producer, I'm going to add the right to reproduce and the right to distribute the CDs, because they have to create about 1,000 CDs to distribute and sell. So it's not going to be just the right to distribute, because I understand that each right works independently of each other, and the right to distribute doesn't give you the right to reproduction, if you understand what I mean. So the right to broadcast, like maybe you are watching DSTV, doesn't give you the right to publicly perform any content you paid for on DSTV. That is the copyright law. That's what the copyright law says. Now let me go to the cocoa of the oral. That means the contention, the main ingredients of the word and the judgment that the judge passed. So the judge is saying that as long as a user of a copyrighted work has paid DSTV subscription fees, it will amount to double compensation if they have to pay performing rights organizations like MCSN and BMI for the right to use the copyrighted work, or for the right to allow other people use the copyrighted work. So now let me explain subscription fees and license fee. A license fee is a fee that is like a compensation paid by the user of the work to the owner of the work to collect permission or to be granted permission to use any of the economic rights of the author or the owner of the work. So basically, sync licensing, I want to put out a movie and I need songs on that movie. So basically, I'll just approach the owner of the song. I want to use that. Hello ma, hello sir, I want to use your song in my movie. Take this amount of money. Let us sign an agreement. Give me the permission to use the song for a certain number of time. Give me the non-exclusive rights. That is basically license fee. Then a subscription fee. This is basically just an amount you pay to a DSP, a digital service provider, or a distributor, or any DSPs, or maybe a non-interactive platform like Dstv, the right to watch the content on that platform for private use, not for public use or commercial use. If you understand what I mean. So these are different things. So if you are just paying subscription fee, you are just paying that subscription fee to be able to have access to copyrighted work on that platform. Let me cite another example, Instagram. So now Instagram has been very strict regarding the use of copyrighted music on their platform, to the point that if you don't use a song on their platform, if you add another song outside their platform, on your reels, on your pictures or anything, they will take down your account because they are very strict to copyright infringement. So basically what Instagram does is that they pay a blanket license, just like DStv pays for a blanket license to AVRS or to all these collective societies. Instagram also pay a fee for blanket licenses to these collective societies for users like you and me to use music on their platform. So if you go and import another music that is outside their platform into their own platform, they will take down your account because they can come against Instagram for the use of that copyrighted work on their platform, because Instagram has not paid for the blanket license. You understand what I mean? So we can always apply it to this scenario too. We are only using Instagram, the songs on Instagram, although Instagram is free, but we are only using Instagram, the songs on Instagram, to make our reels look nice, look good, to make it interesting. But the moment you want to bring another song from outside Instagram platform, Instagram takes our account down because it is already an infringement. So the hotel performing these movies to their users or to their clients without paying a license to collective society is already an infringement because they use it for public and commercial use, not for private use. So this judgment sets a very precarious precedent, because now users will use that as an excuse. Users, especially in Nigeria, will use that as an excuse to infringe on authors, on copyrighted work, because the law already says, as long as you already paid, the judgment already says, as long as you already paid a subscription fee to DStv, you don't need to pay another license fee to the owner of the work, because that will amount to a double compensation. So now people can decide to take any song from the Spotify repertoire or the Spotify catalog. They'll be like, at least I already paid my 1,500 naira subscription fee to Spotify, so why do I need to pay another compensation to collecting society or compensation to the owner of the work? It's to amount to, the law already says it's to amount to double compensation. So they can use this as a defense to not pay license fees to owners of work. So anybody can just go to Spotify, take a song off Spotify and put it in their film, sync licensing. I'll be like, I took it from Spotify, I already paid Spotify my subscription fees. Why do I need to pay it? Because the law already says that. So it stands as a very precarious judgment, a decision that can affect the right of copyright owners and copyright authors to get compensated for the use of their work. You understand what I mean? So people will agree with me that they stand with the learned judge that okay, they feel it's double compensation, but then the law says, the copyright law is already clear on what copyright infringement means, and before you can use someone's work, you have to ask for permission and pay a compensation. So that's all it is about. Thank you guys for watching my video, for watching me as I dissect this judgments given out by the learned judge and everything. So yes, how you can support my business, support my career. Please patronize any of my services, buy my publishing speeches for producers, for composers, for songwriters, for lyricists. I have a course on music publishing, and I explained copyright and this economic rights. Like I said, there are about 9 to 10 economic rights, so you can always purchase my course to know more about copyright, the rights, the authorship rights, moral rights, and all of that. The requirements for copyright protection is always in my course. I'm going to put a link to the course on this post where you're watching, and also my YouTube channel, Janet Odunwoye. Make sure you go there, subscribe, like, and watch this video. And I really hope you guys support me anyhow you can for additional free knowledge. Thank you guys. I can't wait to see you next time. Bye guys.